Keeping track of all the landlord-tenant laws of a state can be complicated at first. Every state has a slightly different way to handle landlords and tenants, and some local jurisdictions also provide their own regulations, making the process even harder. However, these laws aren't as complicated to understand as they seem. If you understand the essential rules and rights that you have as a landlord or tenant, you're not going to have any issues in the future. In this case, we're going to analyze the North Carolina Landlord-Tenant Law to help all parties involved draft an accurate lease agreement document that benefits everyone. Keep in mind that if you need information for a specific renting case in North Carolina, the best thing that you can do is seek legal advice from an attorney or real estate manager. Now, let's ask the question, what is a rental agreement? A rental agreement is a form of a contract made by landlords and tenants at the time of leasing a property. These agreements can include both parties' rights and responsibilities, as well as additional information that can be considered important by the landlord. According to North Carolina law, written rental agreements are required if the lease is going to be 12 months or longer. However, it's suggested to every North Carolina landlord to include a written document regardless of the lease duration. This information can help both parties in cases of a legal dispute in a court of law. The North Carolina Landlord-Tenant laws are explained in Chapter 42 of the North Carolina General Statutes. These articles provide all the necessary lease terms for tenancies in this state, as well as the benefits and obligations that landlords and tenants have. North Carolina is generally considered a landlord-friendly state since there aren't many regulations for landlords. Overall, they can enter their property, evict their tenant, or increase rent without advance notice. It's important to note that some local jurisdictions in the state of North Carolina do have strict regulations that affect landlords. If you want to know how these laws work for your specific rental property, seek legal advice. Now, as with every other state in the country, there's a set of rules that the landlord must comply with to keep a legally healthy relationship with their tenants. However, complying with these laws grants landlords many benefits in North Carolina that they may exercise at any point during the lease. Landlords have the legal right to collect rent payments on time using the security deposit to deduct repair costs from excessive damages to the property and recover the rental unit if the tenants don't pay rent on time or withhold rent intentionally. Generally speaking, landlords must provide an inhabitable rental unit for their tenants. Additionally, landlords are responsible for providing repairs within notice, usually specified in the lease agreement. Keep in mind that North Carolina tenants have the right to withhold rent payments if the landlord fails to make the repairs after receiving notice. However, this can only occur under two circumstances. The landlord has given written consent, or a judge or civil magistrate allows it through a court order. The landlord may make repairs for common utilities in the home, such as electrical wiring, heating and cooling systems, running water, and sanitation. Meanwhile, the guidelines for tenants may vary depending on the terms specified by the landlord. Overall, North Carolina tenants have to comply with the following terms. Every tenant has the right to fair housing, which means a property that complies with local safety and housing regulations. If there are any damages to the property, tenants can send the landlord a notice for repair to which the latter has to respond promptly. If the landlord doesn't respond within the specified time frame, tenant rights in North Carolina allow them to stop paying rent until the landlord provides the required repairs. Alternatively, a tenant may choose to terminate the lease if the unit becomes uninhabitable. According to North Carolina landlord-tenant laws, tenants have to do the following to comply with the general requirements of a lease agreement: pay rent on time, keep the property in good repair, and not disturb other neighbors or tenants. While these are the general legal guidelines, landlords may request additional rules tailored to their specific case. Keep in mind that a tenant may not withhold rent without reason. Now, let's talk about rent payment clauses. Currently, North Carolina doesn't permit any kind of rent control policies for tenancies. This means landlords can charge any amount of rent they consider appropriate for their unit. Landlords are not required by law to send an advance notice at the time of increasing rent prices, but the increase should be reasonable. While landlords don't have to charge late fees if they don't want to, they have to follow certain guidelines if they choose to charge them. If the landlord is working with a weekly lease, the fee may be up to $4 or 5% of the rent's total cost. In the case of monthly leases, the fee may be up to $15 or 5% of the rent cost. As for grace periods, a landlord cannot charge extra fees before the rent is at least 5 days late. Landlords may collect security deposits to protect themselves from any additional expenses that may come from unpaid rent or damages. The value of these security deposits may vary depending on the type of lease agreement that the landlord and tenant are working with. For week-to-week leases, it's a maximum of 2 weeks' rent. For month-to-month leases, it's a maximum of 1.5 months' rent. If the lease rent payments frequency is higher than a month-to-month one, the security deposit value may be up to 2 months' rent. Keep in mind that it's prohibited by law in North Carolina for a security deposit to be higher than 2 months' rent. While the standard amount goes around 1.5 to 2 months' rent, the landlord may choose a lower amount if they wish. As for storage, security deposits may be stored in a trust account of an insured financial institution. Alternatively, the landlord can post a bond for the security deposit. The landlord must send a notice to the tenant within 30 days of the beginning of the lease that includes the information of the bank holding the security deposit. According to local laws, landlords must return the security deposit within 30 days of the tenant leaving the premises. If the landlord needs to take more than 30 days to evaluate damages, they may make a final decision within 60 days. If after those 60 days a decision isn't made, the tenant may collect the full amount of the security deposit. A landlord may be able to withhold the deposit partially if the apartment suffered from extreme wear and tear. The deposit can also be used if the tenant decided to withhold rent without reason. In this case, the landlord must give the tenant a notice with all the deductions made from the deposit within 30 days of the tenant leaving. If the landlord didn't provide that notice after those 30 days, they might not use the deposit to cover these damages. A tenant in North Carolina is allowed to terminate a lease after it ends for any reason, but they must send advanced notice to the landlord before doing it. The amount of notice can be the following. For week-to-week leases, it's 2 days of notice. For month-to-month leases, it's 7 days of notice. For year-to-year leases, it's 30 days notice. Additionally, a tenant can end the lease early for any of the following reasons: harassment or domestic violence, early termination clause, breach in the lease, or active military duty. Now, what about eviction clauses? A landlord may send a notice for eviction to their tenant for the following reasons: an eviction notice for non-payment of rent. In this case, the landlord must send a 10 days notice to pay or quit. If the tenant doesn't respond within these 10 days, the landlord can pursue a legal eviction in a court of law. An eviction notice for breach in the lease. In this case, landlords must send an unconditional eviction notice or pursue legal eviction in court if the tenant doesn't comply. An eviction notice for criminal activity. In this case, the landlord might pursue an Article 7 eviction which takes effect immediately. Depending on the type of lease, the landlord can send a notice of up to 1 month for at-will tenants. For your own lease agreement template for North Carolina and for our full guide on the eviction process and laws for North Carolina, click on the link in the description below. If the tenant becomes a domestic violence victim, they may request to terminate the lease early, showing the required proof. Let's wrap this up. One of the best ways to keep a great tenancy relationship is to follow the local and state landlord tenant laws, since they're the foundation of all the agreements made by the parties involved. If you need any more information regarding your area, consider seeking professional help from an attorney. Now, here are some frequently asked questions. Number 1 is, does information about lead paint need to be disclosed to the tenant? If the home was built before 1978, the landlord must send information regarding lead paint concentrations in the apartment. Number 2, can the locks be replaced on a property in North Carolina? Domestic violence victims in North Carolina have the right to have the locks changed if they feel threatened. In these cases, the landlord must comply within 48 hours and change the house locks. If the locks aren't changed within that time frame, the tenant may change them on their own, according to state laws. Number 3, what is the limit for a small claims court in North Carolina? A small claims court is a faster way to settle money issues between landlords and tenants. In this case, a North Carolina small claims court can hear cases of up to $10,000. Number 4, is there housing protection in North Carolina? The North Carolina Office of Administrative Hearings and the Fair Housing Act prohibit landlords from discriminating against potential tenants because of their race, religion, familial status, sex, and gender. Well, that's it for this video. If you want more real estate content for your business, make sure you check out our YouTube channel for more DoorLoop videos, such as pros and cons of month-to-month leases and the most important house rules for renters. Remember to like this video, share it, and of course, subscribe to our channel. Thanks for watching. See you next time.